Good afternoon. It's a wonderful thing to see a full room. Welcome to the third annual Whitlam Institute CPD, examining the legacy of the many legal transformations introduced by the Whitlam governments. Today we focus upon Australian competition and consumer law. After 50 years, the legacy of the Trade Practices Act remains as Australia's principal legislative weapon to ensure that the Australian community reaps the benefits of a vigorous, lawful, and competitive business environment. On behalf of the board of the Whitlam Institute, I am privileged to acknowledge our esteemed speakers: the Honourable Justice Jacqueline Gleeson of the High Court of Australia, the Honourable John Middleton, AM QC, Senior Advisor at DLA Piper, the Honourable Justice Michael O'Brien, President of the Australian Competition Tribunal, and the Honourable Justice Sarah Derrington, AM, Deputy President of the Australian Competition Tribunal. Unfortunately, Federal Treasurer the Honourable Dr. Jim Chalmers, MP, is unable to join us today due to competing national obligations. I also welcome a number of special guests: the Honourable Anthony Whitlam QC, Catherine Dovey, the Honourable John Faulkner, Kim Williams AM, and the Honourable Justice Michael Lee, who will shortly introduce our keynote speaker. I also extend a special welcome to Robert Ishak, Bill Petrovsky, Carlos Jaramillo, and Oliver Gaynor, principals of sponsoring firm William Roberts Lawyers, who this year celebrate their 20th year. In addition to the many great and good members of the legal profession, I also wish to welcome academics and law students from each of the Sydney area law schools, as well as legal studies students and their teachers. We meet today, of course, on the lands of the Gadigal people of the Aurora Nation. I invite Gamilaroi Elder, Uncle Michael West of the Metropolitan Local Aboriginal Land Council, to offer the welcome to country.
Thank you. I'd like to start by saying Bojari Gamilaroi. G'day everyone. How are you? Great. Excellent. What I was going to say, I was lucky to be at the Ruby Hutchinson Memorial Lecture yesterday, where they had the ACCC and ASIC and many of the advocacy groups about consumer laws yesterday and competition, and they play a very important part. So I'm lucky to be at two different events in 2 days that, when you think about it, run parallel with each other, and that. The law, when you think about it, sits behind everything we do, all the different levels of the law. They impact on our lives from the very day that we're born. For me, it impacted me the very day I was born. I was stolen under the legislation of the day that they had for removing children. We need to be honest in these conversations. We need to do a lot of education, which needs to happen. I know we weren't successful in The Voice, but I think that's because we haven't had a lot of education for older people, but the younger people coming through are learning and willing to learn. And I see up there the younger people up there from the different schools and the different universities and that. We need to create a society where no matter what postcode you were born in, the gender you identify, the colour of your skin, the shape of your eyes, your cultural identity, whether you have a disability or not, and whether you're part of the queer community, all those intersections of the individual should be respected, and you should be able to fulfil your dreams and aspirations. That's the society we really want to create. And it's great that everyone's coming here today. And the law, as you know, does impact on all of us in many different ways. I was going to say, here obviously is where we're on the land of the Gadigal, one of the 29 clans of the Eora Nation, and part of the welcome is to educate people. Obviously, if you were in that beautiful harbour, the most beautiful harbour in the world that we see, if you were in a bark watercraft canoe, that would be a Ngawi that you're in. And there's also a suburb in Sydney called Ngawi. The other side of the coat hanger is the Camaragal clan. There is a suburb of Camaray. And when you think heading west in the Ngawi, you go past Wongal, which is the Olympic Park. On the other side is Wallamadigal, and that's where Bennelong's resting, obviously where the Opera House is named after Bennelong Point. But its traditional name is Jabbagali. there was an island, there were middens there, and the middens were taken, a collection of shells, and they were used in lime in the very first buildings. So when you look at Macquarie Street, just here in the Mint, just across the road, you look closely at the mortar, you'll see little specks of shells, but also if you're at the Rocks, which is called Tullawalla Dart's traditional name, you will see little specks of shells in the old buildings and also in Argyle Street. That's just part of the history we have. The beautiful whales that come in here, they would rest in a place called Gomera, which is now called Darling Harbour, with their little calves. We've got a bridge there and we have marina there, so they can't do that anymore, but they do come and visit sometimes. The totems are very important to us. They're part of who we are. They're part of the Gadigal Clan's totems. Other totems in New South Wales, we have Bunda, the kangaroo, and Dinawan, the emu. Obviously, they're on our coat of arms, and they move forward. They don't go backwards. They can't walk backwards. So when we move forward, we need to acknowledge the present, but also understand and learn from the past and acknowledge the past to be better citizens. And when we think about being better citizens, it's not just Australian citizens. I think in the times that we live, it needs to be global citizens when we think about it, because we're going through very interesting times, aren't we? Some might say Orwellian dystopian, one might say. We'll see what happens in the future. We need to be honest in these, and we need to look at our friends and our allies is so important. And one of the things I think is very important, we're just having a bit of a yarn. I remember when I was quite younger, it's time, yes. A wonderful song, but also a movement which Gough Whitlam was elected to Parliament. Very interesting times then, obviously with the Vietnam War on. Unfortunately, I think humans, we can't really care for each other, can we? We need to do a lot better when we look around the world. It's quite scary, and it's quite sad sometimes when you look at the news. We need to be better citizens, we need to be better people, and I see the young people coming through, and I think they're quite willing to learn and to understand how we can create a better world, and that we need to do that. It's important we just take a moment's silence to pay respects to our ancestors, pay respects to Mother Earth, pay respects to all our elders of all our different communities, pay respects to who are our knowledge holders and pass down your cultural identity and your identity, which is so important. And then also pay respects to all Aboriginal and Torres Strait Islander traditional owners, elders and custodians of past and present, and pay respects to Mother Earth, because Mother Earth has been talking louder to us, and the younger generations will have to deal with the issues that we've created along the way, and we need for them to have the skills and the knowledge to work with us to find the solutions to the problems that we have, and to centre ourselves before we start the lecture. So we just have a moment's silence, a moment of paying respects and a moment of reflection. Thanks. We have the beautiful Hawkesbury to the north, the Georges to the south, and Nepean to the west. On behalf of Metropolitan Local Aboriginal Land Council elders and members, we welcome everyone here. We want everyone to have, learn from what is said today, but also make acquaintances, make friends and that, and have a yarn with everyone. Because when you talk to other people, you not only learn about them, but you learn about yourself. And when I look around our beautiful society that we have and people in the room here, I can see from all the different continents around the world and all the different places. One thing I was going to say about our totems, I'm very passionate about a beautiful white bird with black tail feathers, a long neck and a long beak. It's had a parallel with Aboriginal people. Think of this, it's a beautiful wetlands bird, it's been dispossessed of country, it's had to come and live in the city, just like Aboriginal people came and live at Redfern and the surrounds, and it's been blamed for its situation. It's not its fault, it's our fault as humans. We're supposed to be the intelligent species, but are we when I look at the TV? It's called the sacred ibis, sacred in Egyptian culture too, a god. But don't call me a bin chicken, thank you. I'm not a bin chicken. I'm the sacred ibis. I'm very graceful in my flight. I may look a little odd. I may make geese noises. I'm around here in the park there. I was not there 20 years ago, but it's not my fault. Humans have done this. So I'll let you think about that. Always was, always will be Aboriginal land never ceded. Thank you.
Distinguished guests, ladies and gentlemen. Now, the works of Gilbert and Sullivan are not now particularly fashionable, but for those of you who may be familiar with the Savoy operas, you may remember the character of the Lord Chancellor in Iolanthe. And the Lord Chancellor was the ward of all, was the guardian of all wards in Chancery, and appeared in front of himself to make submissions to himself as to why he should be allowed to marry one of his wards, submissions which were successful. I'm here also in two capacities. I'm here as a judge, and in that capacity, a judge of this court. I welcome everyone, and I welcome the Whitlam Institute to the Federal Court of Australia. And as a director of the Whitlam Institute, I'm very grateful for that welcome. And it's a tremendous turnout, and thank you very much for coming. My only other role is to welcome our keynote speaker. I have to be nice to her because she marks my work. But it's not difficult to be nice to her because I've known Justice Gleeson for a long period of time. She's not only a wonderful lawyer, but a lovely person, and she's very generous to have given her time to us today. She was a member of this court from 2014 until she was elevated to the High Court in 2021, and we're very grateful for her to be present today and give the keynote address. So please welcome Justice Gleeson.
Thank you, Uncle Michael, for the welcome to country. It makes me realise it's always nice to realise that you might have a connection with someone. I have met Uncle Michael before, but I also remember the Whitlam campaign song, It's Time. I was living in those days, I was a kid in Bagala Heights, which is a suburb near Manly. In those days, we had a milk truck that would come down the cul-de-sac, and because I was a pretty sophisticated kid, if I was lucky, I would have a coffee-flavoured Move milk. But I wasn't that sophisticated. The way things happened in those days was that kids kind of thought that they had some kind of a political affiliation, but really what it was they had some idea of what their parents voted for. And in the cul-de-sac there were about 25 kids, and we all lined up along familial party lines. But I do think it's interesting that campaign song was so memorable, such a successful song. So today, the profound impact of the Trade Practices Act 1974, an act that was passed when I lived in Bagala Heights as a primary school student. There are many vantage points from which the impact of the Trade Practices Act and its successor, the Competition and Consumer Act of 2010, can be examined. One could do an overview of the whole statute, now a mammoth exercise, or an overview of parts from the perspective of different industries, different classes of consumer, by reference to the Australian economy, economic policy, enforcement priorities of the regulator, or the interpretation and application of the statute by the courts. Across the last 50 years, a mountain of literature written by regulators, lawyers, economists and academics offers a host of perspectives. At the highest level, an important legacy of the Trade Practices Act is a widespread, stable acceptance of the welfare of consumers as central to the regulation of trade practices in Australia. In 2021, former chair of the ACCC, Rod Sims, explained that the transition from the TPA to the CCA heralded a new era in Australian consumer protection. signalled by the very renaming of the Trade Practices Act to the Competition and Consumer Act in 2011. By including the word consumer in the title of the Act, it symbolised that consumers would be put in their rightful place at the centre of a national competition and consumer law. That evolution is remarkable in contrast with the position in the decade before the Trade Practices Act, that is the 60s, when, as economists Peter Carmel and Professor Maureen Brunt remarked, just about every restrictive trade practice known to man is used in Australia. As Ron Bannerman, the first chairman of the Trade Practices Commission, noted in 1982, it should never be forgotten that competition is itself a prime, and perhaps the prime, consumer protection. The TPA has been instrumental in Australia's shift to a competitive economy in the interests of Australian consumers. Now, I had in mind that I would largely be speaking to trade practices practitioners, and I can see now that in the audience there are some students, and I'm concerned that this lecture is going to be a little tricky for you, but I'll try and adapt it to the extent that I can. My hope for those of you who are more educated is that this will be in the nature of reminders rather than revelations, but for those of you who are new to this subject matter, perhaps at least you can get a bit of a timeline about what was going on in relation to consumer welfare between the 1970s and now, that period of 50 years. What I'm going to describe are some of the perspectives of some of the important voices in trade practices regulation about the impact of the Trade Practices Act, with a particular focus upon that impact for Australian consumers. And so, the impact sought to be achieved. As early as 1941, the Labor MP Charles Morgan raged against monopolies, arguing that they would impoverish the workers, the middle class and future generations. But his was a minority voice in a nation focused at that time on protection, nation building and economic development, and indeed war. However, by the late 1950s into the 1960s, the modernisation of the Australian economy became increasingly important to both sides of politics. And of course, in those days, it very much was two major political parties. Without antitrust reform, Earl Warren, the reforming Chief Justice of the Supreme Court of the United States, worried about how Australia was going to grow up. The story of the Trade Practices Act 1965 and its successor, the Restrictive Trade Practices Act 1971, has been told elsewhere. The 1965 Act, described by Gough Whitlam, then Deputy Leader of the Labor Party, as the puny child Sir Garfield Barwick, had been directed to examining 5 types of agreements and 4 types of potentially anti-competitive practices. The long title of the Act identified its limited scope, namely to preserve competition in Australian trade and commerce to the extent required by the public interest. In 1971, in Strickland and Rockler Concrete Pipes, the High Court held that the provisions of the 1965 Act exceeded the legislative power of the Commonwealth. In particular, the Court unanimously held that the Parliament's power to legislate with respect to constitutional corporations did not support the relevant laws. That loss turned out to be a great success for trade practices reformers. The Court overruled an earlier decision to hold that the corporation's power could validly support properly drafted trade practices legislation. The 1971 Act, drafted to derive constitutional support from the corporation's power as it was understood post-Strickland, restored the status quo under the 1965 Act, but its reach was limited. Intra-state conduct remained beyond Commonwealth legislative power, and penalties for breaching the Act were trivial. The 1965 Act has been described as a source of embarrassment for the Liberal Country Coalition government, and the 1971 Act was derided by Senator Lionel Murphy as one of the most ineffectual pieces of legislation ever passed by the Commonwealth Government. Even so, and while the 1965 Act and the 1971 Act might have been false starts, they did embody an important shift towards a competitive Australian economy. The Acts identified the principle that the preservation and encouragement of competition are desirable in the public interest, while providing for the effect of a restriction of competition on the needs and interests of consumers as a consideration that might tend to show that the restriction was not contrary to the public interest. As the member for Parkes, the late Tom Hughes, argued in the House of Representatives, it's sometimes desirable to allow size to develop, because thereby economies of large-scale operation with consequent benefits to consumers may ensue. In 1969, the Australian Labor Party's platform included two important proposals for law reform in the interest of consumers. One, clear consumer protection laws against unjustifiable price rises and unfair methods in trade and commerce. And two, that the Attorney-General of the Commonwealth would be empowered to initiate proceedings for enforcement of consumer protection laws where such an action lay beyond the resources of the citizen. Consumers' rights were undoubtedly central to Senator Lionel Murphy's approach to trade practices reform. Murphy's views centralised the essential role of the state in a mixed economy as the protector of corporate competition and consumers. His faith overwhelmingly was in the capacity of the law to provide the mechanisms through which businesses and consumers could operate fairly. Following the election of the Whitlam government in 1972, it was clear that Whitlam himself intended the new Act to prioritise the protection of consumers. In a statement released to the media in 1973, the Prime Minister emphasised that the primary approach of the government would be to formulate and implement a framework of standards designed to protect both the physical and economic interests of consumers. On 30 July 1974, Senator Murphy took to his feet on the floor of the Senate to move that the Trade Practices Bill 1974 be read a second time. In so doing, Murphy declared that restrictive trade practices had long been rife in Australia and unfair practices in consumer transactions were widespread. Concerning the latter, the Senator argued that the principle of caveat emptor, or buyer beware, was no longer appropriate as a general rule, that the consumer needs protection by the law from trained business executives against whom the untrained consumer is no match. At that time, the Australian inflation rate was almost 16% per annum. Senator Murphy argued that restrictive trade practices contributed to the inflationary trend and reduced the likelihood that the benefit of tariff cuts would be passed on to the public. That increased competition from imports would be of little benefit if not accompanied by increased domestic competition, and that consumer protection would also assist in the fight against inflation. The opposition opposed the bill's passage, arguing that its real objective was to control the entrepreneurial and management side of business and commerce, while leaving the union side of business and commerce to wreak havoc and inconvenience. The consumer protection provisions were opposed on the basis that more thorough consideration was required in the context of state fair trading and sale of goods legislation that might give rise to confusion and unnecessary cost. In debate, Senator Murphy rebutted the opposition arguments, noting that consumer protection provisions had the support of consumer bodies throughout Australia and were not opposed by bodies on the other side of the fence, like the Associated Chamber of Manufacturers of Australia and the Australian Industries Development Association. And so it was that with the support of two crossbenchers, the Trade Practices Act of 1974 was enacted and commenced on the 1st of October 1974. The purpose of the bill was not to promote competition per se. Rather, it was to control restrictive trade practices and monopolisation and to protect consumers from unfair commercial practices. In the context of a rapidly accelerating international movement towards increased cooperation and trade, the TPA brought Australia into line with international thinking and legislation concerning the promotion of competition. Less than 2 years after the enactment of the TPA, then Minister for Business and Consumer Affairs, John Howard, established the Swanson Committee to consider the operation and effect of the Act, including what could broadly be described as the Act's impact. The Swanson Committee's report was published in August 1976. The report concluded that there's widely expressed support throughout Australia for the central philosophy of the TPA, and that the idea of competition and its benefits has been embraced by the public, the business community and political parties alike. The committee observed that in the short time that the 1974 Act had been in operation, it had affected a great many practices previously held by the businesses concerned to be legitimate and appropriate to the Australian market. The committee concluded there was little doubt that consumers feel that they've gained substantial benefit from the Act, particularly from Part 5, although there was real difficulty in striking a balance between the social costs involved in consumer protection and the social benefits derived from it. The first edition of Miller's Annotated Trade Practices Act was published in 1979. Miller recorded that although still in its infancy, the 1974 Act had produced more legal, administrative, business and political activity than even its strongest supporters could have anticipated. And therein lay the justification for a work, now in its 46th edition, that became an essential, approximately annual purchase for any half-serious Australian trade practices lawyer. As to legal activity, writing in 2021, former Chief Justice of Australia, Robert French, noted that most judges appointed to the Federal Court in 1977 would not have had an education in antitrust law or particular issues raised by the intersection between law and economics. The newly minted court was confronted with standards that were not necessarily legal in nature, referring to a substantial degree of power in the market, eliminating or substantially damaging a competitor, and so on. To adopt what international legal academic Imelda Marr has said, one of the most distinctive characteristics of competition law is its dependence on the discourse of economics. Since its establishment, the judges of the Federal Court became well versed in the language of economics and its intersection with the law. Under the leadership of Chief Justice Alsop, the Federal Court's work was organised into national practice areas so that the Court now allocates competition matters, including economic regulator-related matters, to a small pool of judges with expertise in the relevant provisions of the CCA and assessing evidence of economists and other experts on issues such as market definition. In 1982, Ron Bannerman authored an article, Competition as the Regulator, in which he argued that the impact of the 1974 Act was deregulatory rather than regulatory. That is, it was competition rather than the Trade Practices Act which regulated the marketplace. According to Bannerman, the TPA encourages competition to stand in place of government regulation and industry restrictions and to compel adjustment in response to changes in technology and industry structure. The consumer protection provisions, although regulatory in the sense of prescribing standards of conduct, run parallel to the competition provisions and do not dilute their thrust. For Bannerman, the consumer protection provisions of the TPA were part of the framework in which competition has to proceed, for they stipulate basic standards of commercial probity for the benefit of consumers and ethical traders alike. Focusing on misleading or deceptive conduct in the course of advertising or marketing, pyramid selling, and charging for unsolicited goods and services, Bannerman argued that the consequences of the TPA's prohibitions for consumers were that they're better able to make their purchasing choices and to activate and take advantage of competition that stays closer to the fundamentals of price and quality. And very simply, every consumer who is not misled is that much better off. By 1994, that is 20 years after the commencement of the Trade Practices Act, Professor Maureen Brunt, who had in the 1960s observed that practically every restrictive trade practice was engaged in Australia, now said, these days it's not restrictive trade practices, but competition that is regarded as the norm in Australia. In 1999, Alan Fells noted that that a study reported in The Economist stated that Australian laws are the best in the world at preventing unfair competition and ranked Australia's competition laws as the fairest. In 2004, Robert French, then a judge of the Federal Court of Australia, was more critical, arguing that Australian competition law had evolved to cover a multitude of sins. Subject matter areas introduced into the TPA since 1974 included access to services, unconscionable conduct, industry codes, liability for defective goods, GST price exploitation, price surveillance, the telecommunications industry, and telecommunications access regimes. French observed that as enacted, it was an act of faith in the absence of any prospective cost-benefit analysis. That faith, French said, had endured. However, he argued, the original single consumer welfare purpose of the Trade Practices Act, since affirmed by the introduction in Section 2 of a statement of the object of the Act, as the enhancement of the welfare of Australians through the promotion of competition and fair trading and the provision for consumer protection, had changed in favour of the protection of particular classes of competitor and protection for consumers going on beyond protection against various species of misinformation. As examples, French referred to the authorisation process and the judicial broadening of the application of Section 52 to cover large-scale corporate and commercial disputes as a universal norm of commercial behaviour applicable to corporations and through the Fair Trading Acts of the states to individuals, whether they're dealing inter se as traders or business people or with members of the public as consumers. His Honour also referred to Section 65 A, by which the operation of Section 52 and other provisions was limited in the case of prescribed information providers. French concluded by deprecating the use of competition laws as business protection laws. A few years earlier, Bob Baxt, who had also been chairman of the Trade Practices Commission between 1988 and 1991, and Edward Archibald had complained that the relatively simple and uncomplicated TPA, as enacted, had been subjected to changes which do not deliver many, if any, of the benefits asserted by the proponents of those changes. The destabilisation of the original balance struck by the TPA was said to comprise injections of excessive welfare concepts and some rather surprising decisions in the courts. For Baxt and Archibald, the outcome was far too much emphasis on the protection of small business and to a lesser extent on consumers in situations where one would expect competition to provide them with their optimal protection. In 2006, the then Treasurer Peter Costello asked the Productivity Commission to undertake an inquiry into Australia's consumer policy framework. Reporting in 2008, the Commission's premise was that Australian consumers had benefited greatly from recent economic reforms, including reduction in trade barriers and competition policy reforms that put downward pressure on prices, enhanced product quality and increased consumer choice. However, consumer markets were changing. For example, most Australian markets were much more competitive than in the past, particularly because of economic reforms and the growth of the internet. Of itself, this reduced the need for government intervention. A more nationally coherent approach was needed, including a single national generic consumer law. The Commission proposed that the TPA should be the stepping-off point for the new law. The Commission considered that the current range of enforcement tools in the TPA were inadequate to provide for effective and proportionate enforcement. Accordingly, the Commission proposed that the relevant regulators should be given greater enforcement powers, including to seek the imposition of civil pecuniary penalties with recovery of profits earned by a supplier from illegal conduct, banning orders and substantiation and infringement notices. The result was the renaming and recasting of the TPA as the CCA, including the Australian Consumer Law and a schedule to that Act, which came into effect on 1 January 2011. The Australian Consumer Law has been described as the most significant development since Federation in the consumer protection field, and the passage of the CCA is the most far-reaching consumer law reform since the inception of the Trade Practices Act. The object of the CCA remains in the same terms as Section 2 of the TPA. the CCA maintains the essential structure of the TPA in which the competition and consumer protection policies are advanced in a single statute. In conclusion, in March 2015, the Harper Competition Policy Review published its final report. The panel started with the now familiar proposition that competition policy is aimed at securing the welfare of Australians, and observed that a focus on the competitive process rather than individual competitors and the interests of consumers is a well-established principle of competition policy across the globe. Noting that Australia had enjoyed continuous economic growth since the early 1990s and had weathered the global financial crisis of late 2008 without a recession, the panel identified as key features of Australia's competition landscape: 1, the rise of Australia and other emerging economies; 2, Australia's ageing population and falling workforce participation; and 3, new technologies that were digitally disrupting the way many markets operate, the way business is done, and the way consumers engage with markets. It would be obvious to anyone that the context in which the Harper Review was conducted is decidedly different to the context in which the Trade Practices Act was enacted back in 1974. Even so, in 2021, the ACCC Chair, Rod Sims, observed that the TPA, in all its versions, has long served as a powerful instrument in ensuring the proper functioning of Australian markets. Last year, the current ACCC Chair, Gina Cass-Gottlieb, reflected, "The lawmakers of 1974 could not have imagined products and services available in our technology-enabled global world of trade and commerce. They did envisage the ongoing importance of setting clear guidelines and principles for competitive and truthful business conduct." The TPA remains the skeleton of the CCA and consequently the skeleton of Australian trade practices regulation. In particular, the maintenance since 1974 of the prohibition against misleading or deceptive conduct has been, as Professor Stephen Caronis noted, a powerful weapon to protect consumers, a powerful weapon to protect businesses, providing work for battalions of lawyers over the last 50 years. The trade practices' enduring impact is rightly the subject of satisfaction and pride by those innovators whose efforts led to its enactment in 1974.
Now, you're not going away and not escaping that easily, because we're going to have some, we've got a period until, for a little while for questions, and I hope somewhere there's a microphone that's going around. Yes, there is. So please put up your hands all at once so we know where the microphone should be directed. All right. Well, I'll ask a question then. Now, I think we can all, a number of people in this room can agree that one of the most important things you said in your speech was the fact of providing work for battalions of lawyers. That's a very good thing in and of itself. But one of the criticisms that is commonly made of the current legislative scheme is through a process of accretion, it's become increasingly complicated. Mm. Definitions buried in this very obscure way. Do you think there is some likelihood of there being some wholesale simplification of these laws over the course of the next decade or so, or would that create more problems than it would solve?
I would love to see something like that, and I would love to think that that's not beyond the talents of good draftspeople instructed thoughtfully about the real policy imperatives. Before we started, I had a really conversation with former Senator John Faulkner about the importance of civics in our community, and it always strikes me as a terrible or a very unfortunate thing that our legislation is often so impenetrable that people who want to understand what their rights and obligations are can't readily find the answer to that, let alone judges who have been practising for 40 years, as I have. I think my perspective on that, particularly in relation to competition and consumer law, which was an area where I did do some practice as a barrister and as a solicitor, is that some of this comes down to confidence in the courts to interpret broad norms of behaviour. And when Parliament worries that the courts will interpret very general words in a way that is displeasing to them, a reflexive response to that is to be more and more prescriptive. So being idealistic, I think that one possible answer to that comes back to what Mr. Faulkner was talking about in terms of education about civics. One of the most fantastic things about, I think, our Australian constitutional context is that we have compulsory voting. That gives us all a real interest in understanding what's going on in our important laws, but in order to really take advantage of it, we need to have a fighting chance at understanding our system and at understanding the laws that are behind that. And then being perhaps even more idealistic, if we understood that better, we might have more confidence in the courts to interpret broader norms of behaviour, and we might be able to have simpler laws. How about that?
Hi, this is kind of to build on that question really, but do you think that the splitting of particularly some of the misleading or deceptive conduct type provisions across multiple different acts has added to or kind of diluted the impact of them for the consumer?
I think that would be an area for study, really. I mean, I guess over the years, as the consumer law now has the general norm, and then it has a multiplicity of different specifications of that norm, and then you have something similar in the Corporations Act and so on. Lawyers have responded to that by still relying on the general norm and then trying to find the one or more of the specific norms that will fit the particular case. And it would really be a question for study to see how that has played out in the litigation. Have there been cases where the specific norm has been upheld but the general norm hasn't? I think it really just, what it certainly does is it creates a felt need on the part of the lawyers to identify all the possible applicable iterations of misleading or deceptive conduct that might be relevant, how much value it actually adds. And I'm not meaning to be sceptical, but more to be curious about that. I just don't know. Yeah.
I might throw my 2 cents worth in about that, because I have to, Justice Gleeson's now at these ethereal heights, so you don't have to worry about this. But as a trial judge, you have to wade through this legislative porridge constantly, and you get lots of barristers who are like nervous first-year law students who just throw everything into a pleading because they're terrified of falling in a crack.
What about nervous intermediate appellate court judges?
Exactly. And so the amount of time that's wasted in parsing definitions about what constitutes a financial service and various things is an enormous waste of money. So I would be a great advocate for simplification.
I just wanted to make a comment
Yes.
on that, because the Law Reform Commission did a lot of work on simplification of the...
This is, for those who don't know, Justice Derrington was a former president of the Australian Law Reform Commission.
But on this point about misleading and deceptive conduct, specifically, Elise Bant and Jeannie Marie Patterson did a project on this over the last 4 or 5 years, and I've just found the article. It's in the UWA Law Review. And I think when we were doing the law reform project work, they identified 21 different iterations of this, the misleading and deceptive conduct formulation. So that really explains where the problem lies.
Thank you very much for your remarks. My name is Ruth Med from Women on Boards, and I am not a lawyer, which will be very obvious shortly. I think what you said, that competition is the primacy for consumer protection. Today, of course, the matter of the supermarkets inquiry came out, which sort of gave us a sort of half-baked answer about competition. So my question really is, do you think there's more that needs to be done in the legislation to entrench competition? And how can you do that? It's not clear to me it's terribly easy.
I would not feel comfortable expressing a view about that. I can think of someone who might, and we'll just see whether he whether he stands up. I think, but I guess the framework is more than how do you entrench competition, how do you make way for competition in the context where obviously Australia is it's a relatively small economy, and it's unusual to have more than 2 or 3 competitors in any one industry. But I did notice there was an article in the paper this morning saying that I think it was to the effect that Australian supermarkets are particularly profitable. I'm sorry that I can't, I'm not a policy walla, so...
I'll only say my default position is there's too many laws. It's all too complicated. I think that the process of simplification is a very good idea, and I think there are very well developed a series of legal protections when it comes to competition. It's primarily an issue of enforcement. Now, we've got time for one very quick question, but I'm going to ask it because there are a lot of students up in the top, and this might be the one chance they have to hear about what it takes for someone in your position to become a High Court judge. And should they, and there'll be a lot of people there who I'm sure would like one day to have that position. So how do they go about it?
Right. Gee. It's a certain combination of hard work and luck, I have to tell you. But I was always taught the harder you try, the luckier you get. And looking back, I don't want to understate the significance of luck, but I think that one thing that's important is to be looking around really carefully for the opportunities that present themselves to you. Sometimes something that looks like bad luck can actually turn out to be very good luck. You know, the horrible boyfriend dumps you, but it turns out that means that the next week you meet the really nice one. It's just to put it in blunt terms. So I don't think you necessarily have to have a great passion for law. I think you have to have a curiosity and be willing to pursue that curiosity, however uncool that might happen to be at the relevant time. And you have to back yourself. You have to know what you're good at and know what you're not good at, and look out for mentors. The old codgers can help you in ways that might surprise you, so don't ignore them.
All right. Well, can I ask you then to thank Justice Gleeson for her contribution?
It's my pleasure now to welcome you to our panel session, which will be chaired by the Honourable John Middleton AM QC, a renowned former judge of this court who served here for 16 years, during which time he also served as the Deputy President, then President, of the Australian Competition Tribunal. His Honour was a past presidential member of the Administrative Appeals Tribunal, as well as a part-time commissioner of the Australian Law Reform Commission. He is now a senior advisor to DLA Piper. His Honour is joined by panellists Justice Michael O'Brien and Justice Sarah Derrington AM of the Federal Court of Australia, respectively the President and the Deputy President of the Australian Competition Tribunal. The Chair will very shortly offer a more fulsome introduction to each of the Honourable Judges. Following the addresses of each of the panelists, we will again have an opportunity for Q&A, which will be managed by the Chair. We have again 2 microphones. Please wait until the microphone comes to you and your raised hand and before asking the question. But thank you very much, and over to you, Mr. Chair.
Thank you very much for that introduction, and welcome everybody. I am basically just going to chair this session, but I do want to say a few things, and after about an hour I'll hand it over to the others. One thing I do want to say, picking up on a comment that was made by Her Honour this morning, the question you raised about proliferation of laws, all saying the same thing. Another problem that I think exists in the regulatory sense is the layer of laws. So you've got the statute, you've got then the sub-delegated legislation, then you've got their guidelines, and then you've got whatever else there is, which I think is very hard for a citizen to know what the law is. And, we make jokes about how we sit, trial judge has to get through all the law and then goes to intermediate court and eventually goes to the High Court on issues that directors or small business people have to decide what the law is in actually carrying out their job. So they haven't got the advantage of waiting 3 years to work out whether they've done something wrong or not. So the laws have to be accessible so that the public will know what they are, and that's, I think, one of the crises we have at the moment. And simplification of laws is a very important thing, and as you know, in the financial services legislation, which Sarah talked about, we're trying to do something about that. Anyhow, I've got that off my chest. What I want to talk about before the other panelists is about mergers, so it's topical. A lot of things are happening in that space at the moment. Most of you will know that there's been reform and a new Act of Parliament introduced, which will operate in January next year in its formal sense. There have been significant changes in economic theory occurring over many decades. But at the moment, there's an increasing attention being given to a number of things. We know about the problems with the supermarkets, but there's the proliferation of digital platforms. It's causing a lot of attention at the moment. And the dominance of a small number of these is one of the issues that arises. And then there's the issues arising with AI. And as Her Honour Justice Gleeson mentioned, of course back in 1974 couldn't anticipate these things coming about. But the tools that we can use to deal with these things have been created over a period of many, many decades, and the jurisprudence, and you just have to tailor a lot of those things to the new things that are existing. It's like, you know, many of you are involved in defamation law. We didn't really have the problem of it being done on the internet or platforms or whatever, but we had the defamation laws. We just had to apply them in a different setting. And judges are able to do this, and the legislature sometimes catches up. But basically, we've got the history, we've got the knowledge to deal with these things. I'm going to talk about merger law for the moment and the reforms. And competition law relating to mergers seems to get the most of the public comment. Mainly, I think, because there are big players in it who have the voice of various stakeholders. That's a word we could use. But maybe I'll just describe what's happened. There's the existing framework dealing with merger is going to be replaced with a mandatory and suspensory administrative system for acquisitions. So there's a fundamental change, taking away the role of the courts, not to the whole extent, obviously, there'll be a review I'll come to, and moving it to the executive arm of government, to the administrative regulators. That is a fundamental change, and a lot of work went into saying whether that was a good thing or not, and that decision has been made. So the Commission will be the first instance decision maker in dealing with mergers. With foreign acquisitions, they'll still have to be subject, obviously, to the Foreign Acquisition and Takeovers Act of 1975. So for those who are not that familiar, I'm just going to say that, just outline what happens with this new legislation. A corporation or person as a party to an acquisition must provide a notification to the Commission if the acquisition is a notifiable transaction, unless the Commission has determined that the acquisition does not require notification. The Commission must undertake an assessment as to whether the acquisition is likely to substantially lessen competition, so that's the same gist, or result in a public benefit. In doing so, the Commission must publish details of the acquisition on the Public Acquisitions Register and engage with businesses, stakeholders and the community. The acquisition must not be put into effect unless the Commission has made a determination that it may be put into effect. The amendments create a two-phase process, and you'll hear a lot about this as the reforms are implemented. And it's firstly dealing with whether or not there's a substantial lessening of competition, and all acquisitions will be considered by the Commission in the initial stage, which is known as Phase 1. And where no competition concerns are raised, the Commission may quickly determine that a notification acquisition can proceed. For acquisitions the Commission is satisfied could be likely to substantially lessen competition, the Commission may decide that the acquisition be subject to a further in-depth stage, which is known as Phase 2. Now, timing is one of the things that the publicity dealing with the reforms said was a good thing, because I think you may have heard the slogan for those in the industry: the merger reform, a faster, stronger and simpler system for a more competitive economy. So they're the aims. And one of the very important issues is timing. So that will require the ACCC to have resources, and will require it effectively to keep as tight control on how long it takes. There are a number of things in the Act which trying to promote this idea of efficiency and timeliness. So there's restrictions on reviewing and going to the federal court under the ATJR. So one of the problems that I must say I found when I was a judge as well as a tribunal president and member is that often parties would try to race off to court and interrupt the process and drag it out. And they did sometimes for tactical reasons. So the idea of the legislation is to stop that, to let the ACCC make its decision and go through the various stages that need to be done. And there's requirements on the Commission to give notice, to do things in time. The Commission, as the decision maker, has, though, various responsibilities. It must accord procedural fairness. This means they must give affected parties the opportunity to be heard. How that happens is up to the Commission. There are general rules which we all know about, the hearing rule and the bias rule, which they must adhere to. And there'll be an obligation to give reasons. So that's the process. And then at the end of all that, people are either very happy or they can go to the Competition Tribunal. So I'm no longer president of the Competition Tribunal. It's going to be a busy place. I can only see more and more work going there, and that will require, again, resources. I just want to think about looking ahead. So in one way, the ACCC won't have to worry about court proceedings in the initial stage. Court proceedings are costly, time-consuming, delays, there's appeals and all sorts of things. So in one way, the way ahead is that it should be efficient in that way as far as an administrative decision maker. As you know, there's no burden of proof in administrative decision making. When you go to court and you do civil cases, there's the burden of proof on usually the person who brings the matter, unless statute reverses it. On the balance of probabilities, you've got to work out whether you get over the hurdle and you have that onus. With an administrative decision maker, it's usually a degree of satisfaction. And you reach what is called an affirmative belief. It's harder to describe more than that. You'll only know it when you see it. It's like when in the criminal area you try to explain to a jury beyond reasonable doubt. The more and more you try to explain it, the more and more it gets complicated, and the more and more appeal courts say you shouldn't have done it, because everyone's supposed to know it. So it's an affirmative belief, and that's the administrative hurdle. So you don't have the same issues that you may have with a court. The other thing which the legislation specifically mentions is that there needs to be considering whether the acquisition will create, strengthen, or extend a position of substantial market power. I don't know if those considerations wouldn't have been already taken into account if one is having to look at the situation and a particular issue was brought to the Tribunal or the ACCC's attention. But in any event, those matters are now specifically said that one has to look at. So if there's any doubt about it, it's now affirmed by the legislation. Recently, the ACCC issued guidelines on what's called serial and killer deals. So these are merger assessments and the detailing of analytical assessment to be made by the ACCC. This is part of the transparency which is to be brought within the new system. And transparency is going to be very, very important. So one way you'll get it is by the reasons. You'll see what has happened in the past. Administrative decision makers are not bound by precedent, like a court is, but normally it's good governance to be consistent in various approaches that one makes as an administrator. It just makes common sense. So having guidelines also assists with predictability. And so the people who are subject to these laws will know how to prepare. So when we're talking about the serial issue, we're looking at what we call the incrementally increasing market share. Chain stores, classic example. And they cause a regulator like the ACCC to need to collect information on previous and future plans and the impact of the individual acquisition and the series of acquisitions. So it would be a fact-finding mission of the ACCC, which would probably go a little bit further than normal. And they've got the tools to do that, as we all know. They can require information to be given. It will have to be done relatively quickly in a timely way. The killer deals, this is where you target someone and they're required so you prevent future competition. And the example that has been given is the digital platforms, where you actually can stop further development. The digital era, it brings the long-term investment to reach scale. That's one of the issues with a digital situation. So that's a different thing. It's like with the pharmaceuticals. It takes a long while for drug development over a period of years. So with competition concerns, you've got to look at those different elements to work out how you're going to work out whether something is substantially less in competition or whatever. So it's the same concepts, just you're looking at maybe a different lens or making different inquiries, but you've still got to make the same assessment. It's a evaluative assessment at the end of the day. I think lots of judges have opined about how difficult it is because sometimes, well, all the time, you're looking forward. So you can look at what's happened in the past to assist you, but you're looking forward. I know some regulators thought that my looking forward was a little bit misty. Thought they didn't put it as nicely as that. But hence we've now got the merger reform. So if I've done anything, I brought about reform. But it's obviously an evaluative exercise, but it has to be done quickly. I'm going to not say any more other than there's a book out. Now, as a judge, I couldn't sort of try to sell goods, but I'm a solicitor now. No, it's a book, Competition Law and Economics in Australia. It's to really celebrate the 50 years of competition law. The reason that I've got it in my hand is that I'm one of the very small group of editors that's involved in this book. Justice O'Brien has a chapter in it. I've added a chapter to it. Robert French has put a chapter in it. So it looks back, it looks forward, it looks at what the situation is now. And there's a second volume coming out in August, I think, with other people. And what it has attempted to do, which if I may say so, putting aside my contribution, it has done very well and accurately in giving an indication of what the current law is. It refers to some of the changes coming up that are around. On that note, I'm now going to hand over to Justice O'Brien. I've known Justice O'Brien for many years, and when I finished my time on the bench and as president of the Competition Tribunal, and he took over, I wished him all the best of luck. And that was before we knew what the reforms were going to be. So Justice O'Brien has been a judge of the Federal Court of Australia, appointed in 2019, president of the Australian Competition Tribunal, as you know. After graduating from the University of Melbourne with LLB Honours and Bachelor of Science, his honour was admitted to practice as a barrister and solicitor of the Supreme Court of Victoria. He practiced as a solicitor in London between 1988 and 1990 in the field of European competition law and became a partner of the Australian firm Minter Ellison in 1992, practising in the fields of competition and consumer law, corporate law and administrative law. He was called to the bar in 2002 and appointed senior counsel in 2011. As a barrister, he practised in the areas of competition, consumer law, corporate law, class actions, administrative and constitutional law. He was a member of the panel appointed by the Commonwealth Government in 2014 to conduct a review of Australia's competition laws, which you've heard about today, the Harper Review, which resulted in the enactment of the Competition and Consumer Competition Policy Review Act 2017. So I'll now hand over to His Honour.
Good afternoon, ladies and gentlemen, and particularly welcome to the students who are sitting upstairs. I hope that you are able to learn something about one of the significant legal transformations initiated by the Whitlam government in 1974. I hope the name Whitlam is not too unfamiliar to you as young people. Downstairs, many of us have grown up with the Trade Practices Act, and indeed some of us have made a career out of it. I commenced at law school when the Act was still very youthful. I suspect, I don't totally know, but I suspect that John Middleton commenced at law school before the Act was born. The theme of my...
Just not sure how to take it, that's all.
The theme of my remarks today will be the foresight shown in the original framing of the Trade Practices Act, which recognised a complementary role for judicial adjudication and administrative adjudication in regulating competitive conduct in Australia. I'm going to commence with some introductory remarks about the place of Australian competition law within international norms of regulating anti-competitive conduct. I then want to make some observations about the distinctive features of administrative adjudication compared with judicial adjudication within the Australian competition law framework. And then I'll conclude with some remarks about the nature, scope and importance of the administrative decisions that are able to be made under Australia's competition law, particularly by the Australian Competition Tribunal, including now, of course, the new merger regime. So let me start just by making some very broad observations about international norms of regulation of anti-competitive conduct. In the latter half of the 20th century, a consensus emerged amongst countries that conduct market-based economies concerning the necessity for and the benefits of competition law. And the enactment of the Trade Practices Act in 1974 reflected that consensus, although the benefits of competition law were already recognised in Australia with the previous attempt in 1906 to regulate anti-competitive conduct through the Australian Industries Preservation Act. The international consensus extended to the objectives of competition law as well as the categories of conduct that should be prescribed as being antithetical to those objectives. With respect to objectives, there's a broad consensus of the primary goal of competition law, that being to maintain and enhance competitive markets, thereby enhancing economic efficiency, and so as to improve the overall welfare of the country's citizens. However, in many countries, but perhaps not so much in Australia, but in many international countries, competition law has an additional recognised goal of enhancing economic democracy and participation. Maintaining and enhancing competitive market conditions promotes opportunity for individuals and firms to enter markets to compete, promotes fair treatment of smaller firms by larger firms, and reduces the accumulation of market concentration and market power. That additional goal, I might suggest, has become more significant in recent decades, in which digital firms of unprecedented market size and power have emerged. It is a perspective about the goals of competition law that perhaps might be a little underdeveloped in Australian competition law jurisprudence. With respect to the form and content of conduct rules, Australian law reflects the broad international consensus that competition law should prohibit cartel conduct, anti-competitive agreements and concerted practices, misuse of market power and anti-competitive mergers. Much could be said about the robustness and the adaptability of Australia's substantive competition law, including about the mild attempts made by the Harper Review to return the conduct rules to their much simpler form in the 1974 Act, an attempt that spectacularly seems to have failed. But today I don't want to focus on the conduct rules. I want to focus my remarks upon the institutional framework for the regulation and enforcement of competition law. Around the world, different methods are used for the enforcement of competition law, and of course the different methods reflect the constitutional and legal norms that exist in each jurisdiction. There are nevertheless common features, and indeed broadly two main approaches are taken around the world. In most countries, including Europe, Canada, most Asian countries, enforcement of competition law is undertaken by an administrative body and not by the courts. The administrative body is typically empowered to both determine contraventions of competition law and impose sanctions for breach. Typically, the administrative sanctions are subject to review by an administrative appeals body or indeed by the courts. But in contrast, the three countries that stand apart in that framework are the United States, New Zealand and Australia, whereby enforcement of competition law through the determination of contraventions and the imposition of sanctions is entrusted to the courts rather than an administrative agency. In Australia, of course, it's the federal court that's empowered to determine contraventions of the competitive conduct rules and impose sanctions, and that method of enforcing competition law is of course required by the Commonwealth Constitution, which vests judicial power exclusively in courts of law. But with the enactment of the Trade Practices Act, two administrative bodies were created, which have fulfilled, I suggest, vital roles in the regulation of competition law in Australia. The Trade Practices Commission, which was renamed the Australian Competition and Consumer Commission in 1995, and the Trade Practices Tribunal, which was renamed the Australian Competition Tribunal in 1995. And my focus today is understandably upon the work of the Tribunal. Let me turn to just to say a few words about the distinctive features of judicial adjudication in comparison to administrative adjudication, particularly within the competition law framework. Within the Australian legal framework, and particularly the competition law framework, administrative adjudication and judicial adjudication share certain characteristics, but there are differences. It can't be said that one form of adjudication is preferable to the other. Each has advantages and disadvantages, and they are simply different methods of adjudicating and determining issues. In terms of shared characteristics, the fundamental requirements of judicial adjudication include judicial independence, free from all political influence or interference, hearings being conducted in public, all parties being given an opportunity to be heard, and reasons for decisions being given. But in Australia, similar requirements are really imposed upon the Commission and the Tribunal in making statutory administrative determinations under the Competition and Consumer Act. But in terms of distinctive characteristics, there are at least 6 areas where judicial adjudication differs from administrative adjudication. The first is the method of inquiry. The procedures of the Federal Court are adversarial in nature, whereas the procedures of the Commission and the Tribunal are inquisitorial in nature. In practical terms, the Commission and the Tribunal have greater licence to investigate matters for themselves, regardless of whether the parties raise those matters. The second distinction is the qualification of the adjudicator. The judges of the Federal Court are, I believe, experienced legal practitioners, but a judge determining a competition law case may not have any qualifications in economics. Consistently with the judicial method, the court will be informed of relevant economic theory and its application to the facts of the case through expert evidence. and the necessary assessment of conflicting expert evidence. In contrast, members of the Commission are appointed by virtue of their knowledge of or experience in industry, commerce, economics, law, public administration or consumer protection. For the purposes of each proceeding, the Tribunal is constituted by a presidential member and 2 lay members. The presidential members are judges of the Federal Court, while the lay members are appointed by virtue, again, of their knowledge of or experience in industry, commerce, economics, law or public administration. Typically, for each proceeding that's conducted before the Tribunal, one of the lay members will have qualifications in economics and another lay member will have qualifications in industry or commerce. The third distinction between the 2 forms of adjudication is, of course, the form of evidence that may be received. The Federal Court is, of course, subject to the strict rules of evidence, and in contrast, those rules have no application in adjudications conducted by the Commission or before the Tribunal. The fact that the Commission and the Tribunal are not subject to rules of evidence has a very significant effect on the conduct of statutory administrative determinations in comparison to the conduct of proceedings in a court. The evidence before the Commission and the Tribunal will take many forms. It may include witness statements or it may not. It may include expert reports, business records, submissions and the like. But typically, particularly in more recent times with restrictions and time limits placed on the bodies, the evidence is not sworn and is not subject to cross-examination. The weight to be given to any piece of evidence is a matter for the assessment and judgment of the Commission and the Tribunal respectively. The fourth distinction is the application of any burden of proof that John Middleton has already spoken about. Of course, in the Federal Court, contraventions must be proved on the balance of probabilities, but administrative decision-making is not subject to the same notion of an evidentiary burden of proof. It requires the administrator to be satisfied or form an affirmative belief about the particular statutory test. The fifth difference, of course, are rights of review or appeal. Decisions of the full court are appellable to the full Federal Court and thereafter to the High Court. Determinations of the Commission are typically subject to merits review by the Tribunal, but decisions of the Tribunal are then only subject to judicial review before the Federal Court, which is broadly confined to correction of jurisdictional and other legal error, not factual error. And the sixth difference, of course, is timeframes. Experience has shown that there are very considerable differences in the timeframes for the completion of administrative determinations in comparison to judicial enforcement proceedings, although, of course, each case depends on its own facts and circumstances. Typically, I think I can make this generalisation that legal practitioners are strong advocates of judicial adjudication, believing that rigorous court processes facilitate better decisions. Might I suggest, though, that that view overlooks many of the advantages of administrative determinations, including such matters as specialised knowledge, greater flexibility in identifying and investigating issues, and more timely results. So I want to paint that picture of the differences between administrative and judicial adjudication of competition law issues, and now turn to make some brief remarks about the nature, scope and importance of administrative decisions that are able to be made under Australia's competition law. The original Trade Practices Act, from the time it was first enacted, recognised that effective competition policy required more than the mere enforcement of rules of conduct. The primary function conferred on the Commission was, of course, to prosecute or bring enforcement proceedings for contraventions of the competition law, and the Tribunal has no role in that aspect of the Commission's work. But a second important function that was conferred on the Commission from the outset is the power to grant exemptions from the conduct rules. The administrative exemption power, which has the statutory name of authorisation, has been a very significant aspect of Australia's competition law regime from the first Act. The Tribunal is empowered to review those decisions of the Commission. The authorisation power is not the only administrative power conferred on the Commission and the Tribunal. Indeed, since 1974, the administrative powers conferred on the Commission and the Tribunal have expanded and indeed contracted over time. A significant expansion was the enactment of Part 3A concerning access to services provided by natural monopoly facilities in response to the recommendations made by the landmark Hilmer report in '93. And for a period, the Tribunal's review jurisdiction extended to monopoly pricing decisions of Australia's energy regulators. For today's purposes, I'm just going to say a few words about the authorisation power and very brief few words about the new merger regime. I believe it can be foreseen that the authorisation power in the Act will play an increasingly important role in Australian competition law in the future in order to respond to very complex economic questions. The statutory test for the grant of authorisation has remained largely unchanged since 1974. It's framed broadly. In effect, it's a net public benefit test. A benefit to the public has been interpreted as anything of value to the community, any contribution to the aims pursued by society, including as one of its principal elements the economic goals of efficiency and progress. Authorisation is commonly sought in Australia for mergers or other forms of business collaboration where the stated objective of the merger or the collaboration is an increase in economic efficiency. The two most recent authorisation decisions made by the Tribunal involved merger transactions, and the issues concerned competitive effects and efficiencies. The first of the two decisions was the proposed radio spectrum sharing arrangement between Telstra and TPG. And in its determination, the Tribunal expressly recognised that mobile network operators in Australia have historically shared aspects of their networks, and that the commercial and economic benefits of sharing mobile network infrastructure are readily apparent, particularly in regional areas in Australia. However, the Tribunal refused authorisation of the proposed arrangement because of the likely increase in Telstra's market power and the likely weakening of the competitive position of Optus. The second of those two decisions was the acquisition of Suncorp's banking business by ANZ Banking Group, where the Tribunal granted authorisation because it was satisfied on the evidence that the acquisition would not be likely to substantially lessen competition in any relevant market. It's important to emphasise, though, that the net public benefit test for authorisation is not confined to questions of economic efficiency. Environmental benefits are probably the next most significant driver of authorisation applications for collaborative conduct. In 2023, the Commission authorised a takeover of an energy supplier, Origin, by Brookfield on the basis that the takeover would be likely to result in an acceleration of renewable energy generation and storage, which in turn would contribute to a reduction in greenhouse gas emissions. Recently, the Commission granted an authorisation to the major supermarket chains to collaborate in relation to soft plastics recycling, to manage soft plastic stockpiles and to continue with their in-store pilot collection program. The recently enacted reforms to Australia's merger law have already been commented upon, and I'm not going to say really much about it, particularly given the time. I only wish to highlight what's already been said, the effect of the new merger law, and that is to transfer the competition assessment of the competitive effects of mergers from the Federal Court to administrative adjudication before the Commission and the Tribunal. No change is being made to the fundamental competition test to be applied, or indeed to the public benefit test for exemption. So my concluding remark to you today is simply to again recognise what I consider to be the foresight shown by those who framed the original 1974 statute to establish complementary methods of protecting competitive markets in Australia through both judicial and administrative adjudication of competition issues. Whilst judicial enforcement of the conduct rules is a requirement of Australia's constitutional arrangements, considerable foresight was shown in establishing the Commission and the Tribunal as administrative decision makers to provide an alternative forum in which to adjudicate the competitive effects of commercial conduct and balance such effects against broader matters of public benefit and detriment. Thank you.
Thank you, Justice O'Brien. I now would like to introduce Justice Derrington, who I've also known for some time and had the great pleasure of working on the Australian Law Reform Commission when she was President. Justice Derrington was appointed to the Federal Court in 2018. She was educated at the University of Queensland and holds a BA, I'm told, in French and German. It's quite extraordinary. And an LLB honours and an LLM and a PhD in the field of maritime insurance law. And she was admitted to the Queensland Bar and the barrister of the Supreme Court of ACT. And before her appointment to the court, she was Dean of the Law at the University of Queensland. I think it's fair to say a lot of the other citations that I've been given relate to Justice Derrington's interest in maritime law. But she's a member of the Admiralty Rules Committee since 2006, and in 2024 was appointed chair of the United Nations Coordination Committee for Australia. She has also been elected a Fellow of the Academy in Law in 2009 and the Nautical Institute in 2013 and of the Queensland Academy of Arts and Science in 2018. 2021, she was made 2021, I hope. She was made an honorary bencher of Gray's Inn, and she was president, as I've said, of the Australian Law Reform Commission for some time. And in 2022, she was appointed a member of the Order of Australia in the Queen's Birthday Honours List. So, thank you very much for contributing.
Now it's almost 3:15, so anybody who needs to stand up and then sit down again is very welcome, because 3 o'clock on a Friday afternoon, this is not the topic to be discussed. But in any event, I will persist. So good afternoon to all of you. Not only was I the Dean of Law, but in a former life, I was the academic dean for a period at the Faculty of Business, Economics and Law at the University of Queensland. And I therefore have quite some appreciation for Donald Robertson's observations that lawyers are from Mars, economists are from Venus, but at least lawyers and economists are from the same solar system. Now, it's uncontroversial that economics is generally classed as a social science, and Despina Mantasari has observed that much as economics tries to emulate natural sciences in their methods, two main differences still exist between the two realms. She identifies the first as the dual dimension of economics not found in the natural sciences. It is both positive and normative. The second relates to the distinctive methodology of economics, which, unlike natural sciences, faces difficulties in empirically testing the predictive power of theories using complex real-world data. Law, too, is often considered a social science, and many law schools throughout the common law world at least are grouped with social sciences, or at least with the humanities. Professor Geoffrey Samuels observes that law, like traditionalist theology, is a discipline that's governed by the authority paradigm, and it is this paradigm that restricts it in its capacity to make an epistemological contribution to social science thinking. He notes, however, that many legal scholars engage in research that is outside of the authority paradigm. He suggests that one example of that is comparative law. But in the context of our discussions today, competition law must surely be considered another example. Nevertheless, I venture to suggest that many judges, including myself, have been trained really only in the authority paradigm. And so a tension then arises in competition cases between the distinct institutional logics and rationalities of the scientific and economic experience on the one hand, and the legal processes on the other hand. So today, after briefly describing the usual ways in which economic evidence is adduced in competition law matters in the federal court, I want to posit a potential innovation borrowed, some of you will be unsurprised to hear, from Admiralty law. And I think it picks up some of the themes in particular that Justice O'Brien was talking about, and about the advantages of the administrative decision-making process as compared with the judicial decision-making process. And that innovation is to suggest that we should be using economic assessors to sit with judges in competition cases. And such an innovation, I think, has the potential to bridge the gap between the distinct institutional logics of economists and lawyers. Now, as you've already heard from Justice Gleeson, that Australian competition laws are of relatively recent origin. She talked about the 1965 Act and the 1971 Act. She told you how terrible those statutes were, and indeed, when the Trade Practices Act 1974 was introduced, its predecessor was described as one of the most ineffectual pieces of legislation ever passed by the Parliament. That's some praise for that statute. But in fact, we had one as early as 1906, which was based on the very famous American statute, the Sherman Act, and it was very descriptively titled the Australian Industries Preservation Act, an act for the preservation of Australian industries and for the repression of destructive monopolies. It's a bit like the new Victorian legislation introduced last night, I think, that's called the Tough Bail Act, not just the Bail Act. So the change ushered in by the Trade Practices Act represented a deliberate shift in Australia from the administrative enforcement of competition law to judicial enforcement, although retaining some administrative enforcement. But this new Act also ushered in a new focus on economic concepts, something that had not previously been the subject of judicial consideration. And the court-centric nature of modern Australian competition law is the particular characteristic that informs any consideration of economic evidence in the Australian context. Now, evidence of what? You've heard a bit today about the new mergers legislation, and that is legislation that is concerned with whether the acquisition would have the effect or be likely to have the effect of substantially lessening competition in any market. And so the sorts of things that we as judges need evidence of are things like, well, what is the market? What is the actual and potential level of import competition? What's meant by barriers to entry? How do you define a barrier to entry? What is the height of those barriers to entry? What's meant by the level of concentration in a particular market? What's meant by the degree of countervailing power? What do we mean by substantial market power? These are all questions that those of us trained purely in law know very little about, but they are peculiarly within the knowledge of expert economists. In 2021, Justice Jane Jago of the High Court of Australia commented on the importance of theoretical economic evidence as opposed to econometric evidence. And Her Honour opined, in the context of competition litigation, economic modelling exercises divorced from a sound economic theoretical base are easily destroyed. Even thoughtful and theoretically sound modelling exercises are open to extensive debate. So the degree of focus apparent in evidence on economic modelling may be at the expense of critical evidence of economic theory. Evidence of economic theory, particularly if supported by academic literature and analysis involving the kinds of markets in issue before the court, has explanatory power. It can shape and inform the rest of the evidence. It can inform the nature of the modelling, which will be useful. It can explain outcomes and apparent anomalies, and it can assist in gauging the robustness of commercial evidence from market participants. Economic theory also has real predictive power. Evidence of what economic theory would predict in the circumstances, academic analysis of the fit between economic theory and the real world, and how those considerations relate to the nature, inputs and outputs of any modelling evidence is different from the mere presentation of the opinion of one or more economists. The use of theoretical economic evidence was illustrated again by Justice Jago in her judgment in the Australian Competition and Consumer Commission and the New South Wales Ports Corporation, whereby she was able to reach what she said was the sound conclusion that Ports Kembla and Botany do not compete in the same market as the Port of Newcastle once one properly considers the relevant test for defining the geographic market, according to economic theory, principles and practice. In the ACCC and Pacific National Proprietary Limited, the full court of this court observed that there was nothing erroneous or unorthodox in the primary judge's rejection of the identification condition stipulated by Pacific National, that suppliers must be able to identify and target captive customers with a high degree of accuracy. The primary judge had reached that conclusion by accepting the economic theory underpinning the existence of markets defined by a subset of customers who have more limited substitution options as compared to other customers. More recently, in the context of the former Section 46 of the Competition and Consumer Act, I was required to consider competing economic theories in relation to whether there had been a misuse of substantial market power in the national electricity market. That case raised particular challenges given a novel economic theory was posited by one of the experts in relation to a market that is itself sui generis. I won't go into any further detail as the case is under appeal, but for those of you who are interested, it is Stillwater Pastoral and Stanwell and CSE 2024 FCA 1382. Now let me turn to examine how expert economic evidence is typically adduced in Australian competition litigation and how it is subsequently utilised by the court. The debate around the nature of economic evidence and how it should be received, including the operation of restrictions imposed by rules of evidence, had emerged in the 1990s. In the ACCC and Liquorland, Justice Alsop remarked that because economics is a social science, there's a role for the economist to assist the court by expressing in his or her own words what the underlying facts reveal to him or her as an economist and what it reflects to him or her about underlying economic theory and its application. A similar point had been made by Donald Robertson in 2003, remarking, "Legal analysis is a compound of fact and theory. One cannot be separated from the other. This is especially true in competition law, where more explicitly than most legal disciplines, it draws upon economic concepts, there being a blurring of what he called naked facts and facts with an inferential content. Competition law is heavily fact-intensive, but the theory is needed to identify the relevant facts." Robertson, in fact, argued that when explaining economic theories, economists are not giving evidence of primary facts. Rather, they play a role that's not all that different to the role played by lawyers in the adversarial process. In the course of the Hilmer inquiry in 1993 into national competition policy, concern was expressed about the then current court procedures for the utilisation of economic material. And in response, the judges of the Federal Court enacted a new rule of court which took effect from the 1st of January 1994. And that rule provided that the court may, in a proceeding in which a party seeks to rely on the opinion of a person involving a subject in which the person has specialist qualifications, direct that all or part of such opinion be received by way of submission, in such manner and form as the court may think fit, whether or not the opinion would be admissible as evidence. So this is quite different from the adversarial process, much more akin to the way the tribunal might deal with expert evidence. And Justice French at the time noted that the rule recognised that expert testimony adduced from economists and some other experts may be characterised less as evidence than argument. And this is particularly so where the court is concerned with the application of evidence to the meaning of statutory terms involving economic concepts, such as what is the relevant market. The rule subsists in the most recent iteration of the rules of the court that were redone in 2011. And the then Chief Justice of the Federal Court promulgated a practice note relating to expert evidence in 2016. And that deals with matters including the roles and duties of the expert witness, the content of an expert's report, case management considerations, and the like. Now, in this context, it's important to bear in mind the ethical obligations of both lawyers and expert witnesses in the preparation of expert evidence. One must be careful not to invert the process, that is, using the expert's specialist knowledge and advice in order to identify questions that should have been asked already by the lawyers and the assumptions that should have been made on the case theory posited by the lawyers, rather than simply seeking the expert's opinion on the basis of the facts as they stand. Now, this was discussed by the full court of the Federal Court in 2023, constituted by a bench of 5 judges in New Aim and Leung. And in that decision, the full court agreed with the statement that Justice Lee had made a number of years earlier in Briz Connections Finance and Arup. In that case, Justice Lee referred to a practice which seems to have developed whereby a letter of instruction is provided contemporaneously or near contemporaneously with the finalisation of the expert report, and raised a question about whether such a course complies with the rules and is appropriate. And His Honour said, the point of a letter of instruction being annexed to a report is not to act out a stylised ritual, but to provide to the court a transparent indication of what has been provided to the expert and the questions that the expert was actually asked to address. It should be able to be read literally without being silly, as is, at the very least, implicit in Rule 23. The work of the expert is to attend to the questions the expert was asked to address, not to invert the process, as I have discussed. The integrity of the expert evidence process and the independence of experts is best facilitated by transparency of what is being asked of experts prior to or at the time they are forming their opinions, and if the questions need to change because they are misdirected, a record being made of the way of by way of supplementary instructions as to what has changed. And the full court said, we agree. Now, I was faced with a similar problem in Stillwater, where letters of instruction were dated the day before experts' reports were due. I made the observation that attempts to shield instructions given to an expert witness, and perhaps then also to shield the draft opinions, gives little comfort to a court which expects to be able to rely on expert evidence to be given honestly, dispassionately, and impartially. So there's your ethics point for those of you who need it. Now, The Federal Court utilises a range of mechanisms to assist judges to understand, synthesise and deploy complex discipline-specific evidence. We know the standard testimony of an expert. We know about the use of hot tubs or conclaves, where the experts are put together in a room until they bang their heads together and come up with something that approaches a consensus on most of the contentious issues. We use concurrent evidence, where all expert witnesses on a particular topic are in the box at the same time and can be cross-examined by each party, one after the other. The Federal Court Act also provides for the referral of questions to a referee. And so a judge can be assisted by expert evidence in a manner that's known as something akin to a special trial. Justice Stephen in Buckley and Bennell Design and Construction said that where there is a hearing before a special referee, the court's procedures of adjudication are not abandoned in favour of extracurrial settlement of the dispute, but rather the court directs that for better resolution of the particular proceedings, resort should be had to this special mode of trial which the legislation has made available. The judge then uses his or her decision-making power to decide whether or not to adopt the referee's report. It's not a procedure, though, that has been used in competition cases with any degree of frequency to date. Now, Section 37 capital A of the Act makes provision for the appointment of assessors, but only to assist the court in the exercise of its jurisdiction under the Native Title Act. Section 217 of the Patents Act also provides expressly for the use of assessors by the Federal Court. And more than a decade ago, Chief Justice Alsop posited the value of the appointment of assessors in competition cases. Now, assessors are routinely used in the Admiralty jurisdiction in the High Court of England and Wales, but their use was rejected in Australia by the Australian Law Reform Commission in 1986. I wasn't on the commission in 1986. It would not have been rejected. So no provision was made for them either in the Admiralty Act or in the Federal Court Act. Now, they're called nautical assessors in the UK, and they might be considered the original embodiment of the statutory court-appointed expert. Lord Sumner described them in this way. In Admiralty practice, assessors are not only technical advisors, they are sources of evidence as to the facts. In questions of nautical science and skill relating to the management and movement of ships, a court, assisted by nautical assessors, obtains the information from them, not sworn witnesses called by the parties. And more broadly in England and Wales, the use of assessors has now been adopted in medical cases, and medical assessors are sitting with judges in the High Court. Now, of course, what arises are questions of natural justice or procedural fairness, issues that are apt to arise if an assessor is used in important questions. In the Admiralty context, all of those fears have been assuaged by a very detailed set of guidelines that were produced by one of the Admiralty judges in that court. So there is power in the court, and once we get beyond the administrative decision-making of the tribunal, where you do have the benefit of sitting with the two lay witnesses, one can envisage then, either on appeal to the court or where the court is just hearing a competition matter in its original jurisdiction as a matter of first instance, the ability to have one or more economists or relevant lay people sitting with the judge who is supposed to be able to sift through the economic evidence, particularly where that economic evidence is raising new and novel theories of economics that one does not typically read about in the economics literature. It could be of enormous value. I certainly would have found it of great assistance in the Stillwater case had I had access to that. So, to undertake the necessary competitive effects analysis that's necessary in competition law, I suggest it's worth revisiting Robertson's proposition that economists cannot give evidence in the same way that lawyers use the word and in that adversarial context. I think it's worth viewing them as doing something much more important than just giving evidence. They help the lawyers think correctly about problems that involve human behaviour in the marketplace. So his suggestion was that any rules about economists as witnesses should be abandoned. And he said that to the extent that economists assist the court in determination of competition law cases, they too should be regarded as under the same duties as lawyers. He referred to them as assistants in the judicial process. And that's not very far away at all from the concept of an economic assessor, a concept, I suggest, whose time has arrived in Australia. Thank you very much.
We now have some time for some questions. So, someone up the back there, anywhere upstairs, we want a question from you. Yes. Good.
Just stand up and speak about it.
Hi, I'm from East Hills Girls, and I was just wondering, how is the law able to quickly adapt to the increase in AI and the overall speed of technological advancement?
Want to have a go? Well, I actually find it very useful as a solicitor, but that's a different issue. I think it's probably in the last 2 years, I'm going to give it to one of these people, because I've been retired for 2 years from the bench, so I think things have changed in 2 years. But I assume associates use it all the time. Do they, Mike?
I think that's an excellent question. It's an excellent question because I think in all walks of life, including in the courts, we are wrestling with this new technology, how safe it is, how accurate it is, how it might help us, how it might hinder us, how it might lead us astray, but it might make things more efficient as well. And in truth, I don't think any of us can answer that question at the moment, and we're having to work towards the answer. As in all new technologies, we shouldn't be closing our mind to it, but equally, we can't be fooled by it either. It might have the appearance of accuracy and assistance, but that might be a little bit of a fool's gold. It might lead us astray in various ways. So it's a really challenging question. Perhaps one other thing I'll add. In the end, I think what the community expects from the courts and from its judges is to have real attention to the people before the court and who bring their cases to the court. And I think the community still expects that judges are exercising both their knowledge of their law and to some extent a moral compass, a personal moral compass, to make decisions within the framework of the law and to get it right in that sense. And I think still to date the community doesn't expect its courts to delegate that to a machine where we don't quite understand what results the machine is generating. But it's a very good question and it's very hard to answer.
Thank you.
Can I just add, it can be very useful to get basic information, but you've got to be careful it's right. I remember once looking up something about land title and it referred to an act that no longer existed. So you just got to be a little bit careful. But as Justice O'Brien said, it's never going to replace when one has to exercise a discretion or deal with human frailty and deal with those matters, and it will never replace that in my view. But it can be useful. I spoke to a barrister who's been at the bar for about 10 years, and she was writing an opinion, and she got one from one of the ChatGPT things, and she said it was like a first-year barrister's draft. So it wasn't bad.
So there was another hand.
Yep, thank you. That's it.
Anyone else up there? Yes?
Good afternoon. I'm speaking on the behalf of Grammer Boys High School, and I would like to ask you, how does the recent legal reforms in Australia impact the balance between procedural fairness and individual rights and national security? And I would like to get your opinion on it.
All right, gee. It's a very broad question. Do you have any particular reform in mind?
No, anything that comes to your mind, you know.
Well, generally speaking, the idea of the courts is to protect citizens' rights and whatever, so I assume the courts are still doing that. I think they are. Yes. We're very lucky in this country to have, I think, a very strong judicial system across the board. We've always got to be wary of legislation that goes too far to inhibit those rights. There was a Australian Law Reform Commission research done about freedoms and how they were restricted. You start with the proposition that every piece of legislation in one form or another restricts your activity. And the question is whether that's proportional. Is that appropriate? I can't answer it any more specifically than just that.
All right, thank you.
Whilst we're thinking of other questions, when Justice O'Brien was talking about the difference between the Ministry, the Tribunal and the Ministry of Decision Making and the courts, he made some comment about how the courts weren't very inquisitional and the Tribunal was. Well, they obviously weren't. That particular comment didn't apply to Justice Lee's court. So it just depends which judge you have. Any more questions at the top there? Yes?
Hi, I'm on the behalf of Castle High School, and I was wondering, to what extent does the new American politics and law impact Australia's own law, especially in competition and consumer law?
I haven't had experience much of influencing at all, really. We've got our own series of jurisprudence, which we've developed over decades. We've been very lucky to have people who have gone before us who've known a lot about the competition law and those sort of matters. I don't think I've ever needed to revert to an American authority, or even we don't seem to refer to much English authority anymore now. We've got our own jurisprudence. So the answer is no. I don't know if
In the case that I was mentioning that I was involved in about electricity, the claimant's expert came from the US, and that was very interesting because he was the one with the novel economic theory. So it was a very interesting discourse between him and an Australian economist and an English economist. So we do draw on international experts, but in terms of the law that we apply, that is Australian law, not at all influenced by the politics of what's going on in America. But if the American jurisprudence, if there is a case that is very similar, then it may be persuasive or it may be helpful in understanding the concepts.
Another question up there? I'll be coming down below because these questions are quite hard. So if I come to you lot, I'm sure I'll be fine.
So you guys have talked pretty extensively about the relationship between law and economics, and since rates of economic literacy in Australia have been decreasing so much recently, I was wondering, what are your thoughts on the impacts that increasing economic and financial education in both high school and especially legal university courses could have on basically our legal environment in Australia?
Perfect question for Justice Derrington.
I don't think you should become overly specialised at school. I think you should be doing broad subjects to open your mind to all the possibilities. I happened to do economics at high school, but that was only because I hated maths and didn't want to do it. So economics sort of fitted in a little bit with that. But once you get to university, if you want to do law. I think, well, my experience in the law schools that I have been most closely associated with has been that the dual economics law degree is pretty good. That is not to criticise any of the other dual combinations, but the broader your subdiscipline and the more you can read, the better off you'll be. And the better off society will be if we have people who are financially and economically literate, because that is how the world is now. We need sound economies to keep going, and so we need you.
I'm just going to add something again. Oh, sorry, you've got a follow-up question. Why don't you ask?
Oh no, I was just going to say thank you.
All right, oh, good. Can I say it again? It was an excellent question. We have been speaking a lot about economics, and that's fundamental to this law that we've been speaking about today, the Trade Practices Act. For those of us who work in this area and those of us who work with economists all the time, we are so invested in this area of law because we believe it will have a real impact to affect the welfare of everybody. Of course, we're only speaking about the material welfare, the economic welfare of people, but we fundamentally believe in that because that is so important for the citizens of this country. I actually want to encourage anyone who's in the upstairs gallery to have an interest in economics or study economics or matters of such welfare, because it is of such importance to every member of the community. Sadly, decisions are often made, including, dare I say, by governments, which are ill-considered and can harm economic activity and harm economic welfare. Of course, the outcome of that is to harm some of the poorest people in the community when we do those things. So the study of economics, and indeed this area of the law that we work in, is to enhance economic activity, enhance economic outcomes, but for the sole purpose of having material benefits for all members of society, including particularly the poorest members of society. So it's a good thing to study.
Thank you.
Yes, there's another person up the back there. Yeah.
Hello, my name is Mateen from Grammar Boys High School, and my question is, what are the biggest challenges in ensuring justice for all Australians with the current economic conditions?
All right, I should have come down below before that question. Could I have the question again, please?
Yeah.
Give me time to think about it.
What are the biggest challenges in ensuring justice for all Australians with the current economic conditions?
All right. Probably one of the greatest problems is access to justice. It always has been a problem, and I think that has to be maintained and improved. So getting to whatever justice is required, depending on whether it's not dealing with what we're talking about today, but other issues that arise with personal safety or personal welfare. So getting to have justice given to you, you have to get to the place to give it to you. So it's important.
And if you're interested in that topic, Dr. Warren Mundy has just, in the last few months, released a report on access to justice on behalf of the government, and I commend that to you. It's now a question for the politicians to implement what he recommended.
Thank you so much.
All right, now we'll come down. There's one, yes.
Hello, I'm not a lawyer yet either, but I'm working on it. So forgive me if there's an error in the premise of these questions. I've got two that go back to back. The first is whether, given the nature of the company seeking merger authority, whether when a decision from the administration is not, from the tribunal is not favourable, whether you are concerned there's a risk that those companies will simply throw everything at it and cry judicial review, and those matters will end up in court anyway. And a follow-up to that is, Is there a risk that the economic concerns that have been brought into focus in the tribunal will be lost in court, given that the only grounds of judicial review can be on questions of legal error, not factual error? I hope that makes sense.
Do you want to have a go?
Yes. In answer to the first question, no, I'm not concerned about the prospect of judicial review. Whenever there's a change to the law, as there is with this change in the merger law, and I expect a few cases in the early days will come to the tribunal, it'll be understandable if parties get an adverse outcome that they might want to test the law and explore the law and take that to the federal court to see if the tribunal is getting it right or not. I think that's to be expected, not to be feared. In the usual course of these things, that'll happen in a few of the early cases. Either the tribunal will have got it right or will have got it wrong from a legal perspective. It'll be corrected and then we'll all move on fairly quickly. So, yeah, any change of determinations that go to an administrative framework have some cases in the early days. That's the normal course, and it's not to be feared. Actually, I had remembered your second question when I started answering, but I've forgotten now. Could you just repeat the second question?
It was basically around if I'm understanding this correctly, the administration, the tribunal will have greater opportunity to really factor in economic concerns, which obviously is factual evidence rather than a question of law. Where you get an application for judicial review, given those reviews must be on errors of law, not errors of fact,
yes.
Is there a concern that those economic considerations will be lost or their impact eroded slightly by that review process?
No, I don't think so, for the very reason that the judicial review is only in respect of legal error. I don't think it will really go that way. I'll caveat with one remark. There was an example about 20 years ago, a very famous example. I suppose I can mention the judge involved because it is good fun, but Justice Finkelstein on the tribunal in a review of a telecommunications matter accepted certain legal propositions under the various legislative parts. It went on judicial review to the full court. The full court disagreed with some of those economic matters that had been determined by the tribunal. Of course, the outcome of federal court review is the matter returns to the tribunal. When it returned to the tribunal, Justice Finkelstein again reiterated the same views that he expressed in the tribunal in the first place, said the full court was wrong, and there was no more appeal from it anyway, but that was quite a funny example.
The whole idea, I think, of the tribunal, when it gets there, is supposed to deal with all the factual matters, and the court is really last resort if there's something gone off the rails, is the whole idea. People can misuse it. I think one of the most important things that we have to watch with the new merger reforms is the timing of them. The ACCC will have to keep its game up, and the tribunal, if I may say so, will have to do the same thing. And then when it gets to the court, a little less controlled, because it has got a statutory time that has to do things, but hopefully the Chief Justice will organise the court so that the court will be able to hear it very quickly and then determine it. And then if it goes off further than that, well, we can't control the High Court in all respects.
Any respect.
Yes.
Hi, look, I'm Commissioner Janet McDonald from the New South Wales Industrial Relations Commission, and I was very interested in what Justice Derrington had to say regarding the use of assessors to assist the bench to understand the economic evidence, and it certainly given me some food for thought, because on our commission, of course, we also hear extensive expert economic evidence to determine new awards, setting fair and reasonable employment conditions. And indeed, I'm sitting on a number of full benches at the moment considering economic evidence, which is challenging. But in relation to, as I understood it, you considered that there was not the power in the federal court at the moment to have the appointment of assessors to assist in competition matters. or maybe I misunderstood that.
I think we do have the power, we just haven't done it.
Just haven't done it. Save for the fact that, as I understand it, Justice Lee did do it in the Roundup case. And so that's what I was going to raise, the use. I think he used Section 23 and also Section 33ZF, of course, which was in the class action space, but whether 23 is wide enough to use that power, and it just then, again, feeding back into my jurisdiction, how we might approach reform in ours to get assessors to assist.
So I do think we have the power. What I think would be useful would be to promulgate a practice direction to deal with the procedural fairness issues. And I think if it became clear to the profession how those issues would be dealt with when sitting with assessors, there might be more call for them. Judges might feel more confident in appointing them, and the profession might feel comfortable to have them sitting with the judge.
I did a lot of patent cases, and I didn't want to hear a lot about pharmaceuticals and all the sort of things you have to hear about, but that was my job. I did suggest to a couple of the patent lawyers a number of times, well, why don't we, get someone to listen to all this stuff about the pills and everything, and they'll tell me about it. And they reminded me that was my job, to listen to the experts and make a decision about it. So there was that pushback sometimes from the profession, and it depends upon the case. I actually think, doesn't Section 23 give you the power to give everything to the assessor? I thought there was, you must know about this provision. The referee. The referee, don't you have power?
Section 54A allows you to refer out, including an entire proceeding, which is very useful. But the assessor, but I used to go around in different states, and references in New South Wales were very, very common downstairs. And you used to go around and people think you're a Martian for suggesting it in other courts. But the assessor thing was fantastic. Sarah referred to this case about whether Roundup causes cancer, and it came in and I said, and there was a Nobel laureate on one side, Nobel laureate, all these Americans things, and I said, if my Year 11 science teacher, Brother Linus, knew that I was trying to decide what was right between these things, he'd be
appalled.
He'd be turning his grave. And I said, I simply need help. So I appointed this general scientist fellow called Sir John Saville, who had more post-nominals than you could believe, about 64 of them. And he was wonderful. And I sat with him, and I came back to chambers, and I did hear all these evidence from the scientists. And I go, well, let me tell you what I think just happened. And I explained to him, he go, yes, but there was this and this, and what we don't know was this and this, and it was fantastic. And it was a very good illustration of how very intelligent people can be good at things in other disciplines, because he was sitting on the bench with me, and I said, and he said, well, you want this question? I said, well, just ask them questions. And of course, the most wonderful part of it is those experts knew they couldn't pull the wool over his eyes, and so a lot of questions were answered. Yes, Sir John. Yes, Sir John. And if you mean that must mean this, must it? Yes, Sir John. And it just made it so much easier, and it was wonderful. And in fact, I got the agreement of the parties to send my draft judgment to him just to make sure I'd made no horrendous errors, on the basis that they could never see the draft. And I got them all to agree to that, and mercifully he thought it was right. So it all worked out wonderfully well. And I think it is the wave of the future, because these mega cases are just impossible for one person to decide.
Thank you. Now, I think it's time for us to finish, according to my timetable. And John, you're going to come up and wave everybody off. Should we leave? No. Stay. We'll stay here.
Stay here?
Yeah. Okay. Ooh, sorry.
Just whack me right
to the head.
Well, ladies and gentlemen, my task as the chair of the Whitlam Institute is simply to say thank you. I mean, Justice Derrington at 3:15 offered people an opportunity to stand up and jiggle around, but I, of course, can curry favour with everyone because I can let everyone actually off the hook. And this is a great advantage of being, by saying you're the final speaker, which is terrific. And then if you also add the words, and I'll be brief, everyone finds that just fantastic. But my task is to offer the sincere thanks of the Whitlam Institute to all our distinguished speakers. That's our official speakers and also our unofficial Justice Lee, who've been so generous in sharing their time, their knowledge, their expertise with us all. And we're also very grateful, of course, to our hosts, the Federal Court of Australia, and our sponsors, William Roberts Lawyers. So, ladies and gentlemen, this CPD event is the third in a series we've entitled, as you know, Whitlam's Legal Transformations. Earlier CPDs have dealt with legal aid and the establishment of the ART. A little later this year, we're going to be holding a symposium on the Racial Discrimination Act. And I should say that one of the things we're very committed to doing is ensuring that those who join us in these gatherings are getting younger people along and appreciate the fact, as I'm sure you all do, that we've had a number of school students and university students who've been able to participate with us, and delighted that they could join us today also. So we're hoping that all of you will remain engaged in the work of the Whitlam Institute, which, as I'm sure you know, is rather unique in standing aside from the partisan political activity that is more typical of institutes that stand in the name of a former politician. Certainly hope that you will be able to do that, but if you're unable to do that, we certainly hope that just in a moment you'll be able to join us for refreshments. I'm under very, very strict instructions to say to you, and I think everyone had this experience in the break anyway. It all happens on floor 20th, just a floor below us, and it's reached by the lifts and the stairs at the end of the corridor. So to sum up, I just wanted to say thank you all for joining us, and can I ask you finally to join with me in showing our appreciation to our speakers, our sponsors and our hosts. Thanks very much.